Right, so we'll continue where we left off. So we are going on to the case on page 52, Niederman versus Brodsky. All right, what happened in this case? Why are we in this lawsuit? Somebody got hurt, right? Why? How did he or she get hurt? Anyone?
Someone was driving a motor vehicle in a reckless and negligent manner,
Mm-hmm.
and the appellant got hurt.
Okay. Did the car hit? Niederman is the plaintiff. So, did the car hit Niederman? Touch him?
His son?
Yeah, it hit son. Yeah, tragically, but didn't hit him. So, what court are we in? Pennsylvania. Do you remember this court? Okay, which case was that? The very first case we discussed. Okay. What happened in the lower court?
They dismissed it.
Dismissed. Dismissed. If you look at page 52, at the bottom it says, was reluctantly dismissed on preliminary objections for failing to state a cause of action. Okay. So there it was dismissed because the complaint didn't state a valid cause of action. Which means even if all the facts alleged in the complaint turned out to be true, there is nothing that court can do. Okay? That's what's meant by failing to state a valid cause of action. So what should the Supreme Court do if they maintain the same attitude from Bosley versus Andrews? When was Bosley versus Andrews decided? (1958). So 12 years have passed. And it says reluctantly dismissed. Why was the case reluctantly dismissed? What did the judge in the lower court say about this case? Can you tell why the Supreme Court says it was reluctantly dismissed?
In paragraph 3,
Mm-hmm.
it states that the judge noted, like, the impact rule was the basis of why they dismissed
Mm-hmm.
their claim, but he said the impact rule will no doubt eventually be rejected.
Mm-hmm.
But for now, for Harry Niederman, the plaintiff in this action may not be afforded the opportunity to testify
Right.
at the trial.
Right. And he says it is regrettable. Right? And in the end, we are bound by the law as set forth by the Supreme Court of Pennsylvania. So, Pennsylvania Supreme Court's decision in Bosley versus Andrews was, okay, if you have to choose, if you have to choose between the three words, what will you choose? I mean, three phrases. One is, one, compelling precedent. Two, mandatory authority. Three, persuasive authority. Supreme Court's decision will be mandatory authority, right? It is court, it is decision of a higher court in the same jurisdiction. That's why the lower court judge said we are bound by the law as set forth by the Supreme Court. Okay. And then what does the Supreme Court decide in this case? What? Sorry, I didn't hear you.
We decide that on the record before us, Palin may go to trial and he may prove his allegation to cover media and negligent.
Okay. So, does this court abandon the impact rule of Bosley versus Andrews? What do you think? Yes. Okay. So, if you look at paragraph 6, the court says, well, the end of paragraph 4, the court says, by our holding today, Pennsylvania proceeds along the path recently followed by our neighboring jurisdictions and removes this ancient roadblock to appellant's recovery. What's the ancient roadblock? The impact rule, right? Do you remember any jurisdiction that abandoned the impact rule? California. Okay, can you name some cases? We read only 3 cases in this class. Huh? Seleznyov. Okay. Okay. All right. Enough for California. Any other jurisdiction that abandoned the impact rule?
Illinois.
Which one?
Illinois has abandoned.
Right. What's the name of the case?
Nearing v. So
Yes, Nearing v. Izzo or Izzo. I don't know how to read that. That's all on page 33, right? Okay. So these are the neighboring jurisdictions that abandoned the impact rule, and we were going to follow that. So I said in the first class that the rule that common law judges decide cases is stare decisis, meaning stand by past decisions, right? So what happened to stare decisis here? What does the Supreme Court say about their duty to follow precedents? Anyone? If you look at paragraph 6, it says, we believe that it is not sufficient to perpetuate the old impact rule simply in the name of a precedent. Each and every objection raised in the past, which would preclude the appellant in this case from going to trial, can now be answered effectively and persuasively. All right, what are the objections? What are the objections raised against allowing the plaintiff that didn't suffer any physical impact to go to trial and maybe win it?
The first objections was saying that in most cases it will be impossible for medical science to prove that these subjective symptoms could not possibly have resulted from or been aggravated or
Okay.
stated from. Yeah.
Okay. Why don't you read out the second and third objections as well?
The second involves the fear of fraudulent or exaggerated claims.
Mm-hmm.
Finally, there is concern that such a rule will precipitate a veritable flood of litigation.
Okay. So if you look at paragraph 7, the court lists why the impact rule has taken hold in the past. Okay. What should, so how does the court answer each objection? How about the first one? That it's medically difficult to prove causation between damage and the fright, the shock, the mental shock. Okay.
The court claims that the medical progress in the past
Okay.
years would solve the problem for them.
Right. Paragraph 8, the court says progress in the medical field, okay, now allows easier proof on causation. And then the court makes an interesting argument why this difficulty with the causation doesn't really make sense. What does the court say? It's an interesting logical argument.
So they're saying if they're only applying this case to where there was absolutely no impact at all.
Okay.
So in contrast, if there's only a slightest impact, all changes, that
Mhm.
makes sense logically.
Why not?
Impact does not necessarily mean causation.
Right. If causation is difficult to prove, it should be difficult to prove even when there is some impact. All right. So here is accident or some accident, and here is fright, shock, right? And then it will cause damages. Now, if we are worried that this is difficult to prove, then it doesn't matter whether there is a small impact or not, right? Whether there is a small impact or not, it still should remain difficult to prove causation between shock and damage. But for the impact rule only calls out, only removes the situations where there is no impact at all. So it doesn't make sense. And then, if you look at paragraph 11, the court says, even if we assume arguendo는 뭐 그런 면에서 논란이 있다고 할지라도 그런 뜻이에요. Even if we assume arguendo that great deal of difficulty still remains in establishing the causal connection, this still does not represent sufficient reason to deny appellant opportunity to prove his case to a jury. Now you will hear this a lot in appeals on motion to dismiss cases or summary judgment cases. All the cases that are appealed from pre-trial decisions, right? If a case came to the Supreme Court on motion to dismiss, was there a trial in the lower court? Yes? No? Okay, let me repeat that. This is so basic. You should know this by now. All right, if there is an appellate case on motion to dismiss decision from the lower court, okay? Has there been a trial in the lower court? No, right? Okay. How about if appeal was taken from a summary judgment in the lower court? Has there been a trial in the lower court? No. The whole purpose of summary judgment is to avoid the time and expenses of a trial. Okay? The whole reason for motion to dismiss is to avoid the time and expenses of discovery and the trial. Right? It's just earlier. Okay, good. Now, what's the second objection? Fictitious injuries and fraudulent claims. What does the Supreme Court say about that? This, right. Illusory claims can be made even in cases where there was impact. All right. So if you look at the bottom of paragraph 13, the court says, the danger of illusory claims in this area is no greater than in cases where impact occurs, and that our courts have proven that any protection against such fraudulent claims is contained within the system itself, in the integrity of our judicial process and the knowledge of expert witnesses, the concern of juries, and the safeguards of our evidentiary standards. Okay. How about the last objection? What's the last objection?
There will be a lot of litigations.
Right. What does the Supreme Court say about that?
It's not clear that in other states there has lot of litigation occurred, and also judicial system should not concern about the number of the litigation, whether they have to take care of discovering truth as well.
Exactly. Okay, if there is a more number of cases, if there are more cases, so what? That just means the court will address more wrongs, right? The court will just broaden its involvement with the society. Okay, that there will be more cases should not be a reason not to allow those cases. If you look at paragraph 16 on page 55, like in the middle, page 55, left column, 7th line says, it is a pitiful confession of incompetence on the part of any court of justice to deny relief on the ground that it will give the courts too much work to do. Very clear, right? All right, so what rule? It abandons the court abandoned the impact rule, and does the Supreme Court say all no impact cases will be allowed to go to the jury from now on, or are there some requirements or elements that need to be proved for a no impact case to get to the jury? What are the requirements? Has anyone caught that?
If the complaint proves the fact that rule established that the Supreme Court was independent and put him in personal danger of physical effects, and that he actually did fear the force, this case was proceeded to trial.
Okay, so paragraph 17, about 7 lines down, where the plaintiff was in personal danger of physical impact because the direction of a negligence force against him, and where plaintiff actually did fear the physical impact. Okay. So that is the requirement for a no impact case to be recognized as a cause of action. Okay. Compare this to the rule in Atkin-Road. In the Atkin-Road, what was the requirements for a no impact case to be recognized legally, to be recognized as a valid cause of action? What were the requirements in Atkin-Road?
There should be intentional infliction of severe emotional distress.
Okay, can you point to some paragraphs for other people to follow?
Oh, well, I thought it was on paragraph 8, but I think paragraph 10 also
Yeah.
lists elements.
Okay, why don't you read page 34, paragraph 10, and compare that to what Pennsylvania court just did.
The first element was outrageous conduct by the defendant.
Well, I mean, why don't you all read? Yeah. I mean, not out loud, but take some time to read that paragraph, paragraph 10. Okay, having read that, which one do you think? So, that's the test that California court and Illinois court, well, at least California court and Illinois court, as interpreted by federal court in Illinois, right, will require for no impact case. Compare that to the requirement in Pennsylvania. Which one is broader? Which one is more open to no impact cases? California and Illinois one hand, and Pennsylvania, the new Pennsylvania court the other. Which one is broader in accepting no impact cases? Pennsylvania is broader? Okay. Because
the one stated in page 34 requires more intentions and outrageousness in conduct.
okay, intentional causing. Okay. But here, even negligent conduct on the defendant, right, can also give rise to liability, right? Okay, some of you said Illinois, California is broader. Why? None of you said that? Well, Illinois and California rule is broader than Pennsylvania in another sense, right? I mean, it doesn't require the person be in the direction of a negligent force, right? Actually, it doesn't require any physical. It doesn't require any physical. How should I say this? Physical force be applied by the defendant. If you look at paragraph 10, as long as it's intentional, there is no requirement for physical force to be applied. But Pennsylvania requires a negligent force, right? So, for instance, I mean, I talked about this case once, right? On Halloween day, children go trick or treat, and they dress up as monsters to shock the host, right? And one of the children dressed up so realistically that the host just fainted upon seeing the child. And that was considered outrageous conduct in that intentionally designed to shock the host. I mean, that's the whole purpose of trick or treat, right? And then there was a severe emotional distress because she fainted, right? So that will be a good case under the California or Illinois law. But how about in the Pennsylvania rule? It will not be a good case under Pennsylvania law, right? Because Pennsylvania law requires physical force and require the plaintiff be in the direction of that physical force, right? But in Halloween, trick or treat, there is really no physical force. There is a showing of, right? So if you compare, you can see that Acklenroad is concerned about intentional tort, and Pennsylvania is concerned about negligent actions, right? But in broader area of tort, they are both adopting, or they are both abandoning the impact rule. Okay, and if you look at paragraph 4 of this case, the top of the sentence, the top of the paragraph, it says, "Today the cows come home." What's meant by "today the cows come home"? Do you remember this?
Things come back to making sense.
Okay, good. And who said this?
Justice Musmano and his dissent to the
Yes. If you look at page 20, Justice Musmano said, "I shall continue to," he was a minority opinion. He wrote a minority opinion. He said, "I shall continue to dissent from until the cows come home." So the Justice Roberts, writing for the Pennsylvania Supreme Court, remembered that his colleague has written this, and Justice Roberts is basically paying homage to Justice Musmano, who wrote the minority opinion. Okay. What do you think? I mean, one thing that strikes me is for Pennsylvania court to change its decision, the Pennsylvania court, the Bosley versus Andrews, was it negligence case or intentional tort case? Come on. Negligence, intentional tort? Negligence, right? And Niederman, is this negligence case? Yes. But the case you read in the middle, Illinois case, or federal court in Illinois, was that intentional tort or negligence? Intentional tort. Do you think it's easier to change, easier to abandon the impact rule, or another way of saying it is it easier to accept no impact cases in intentional tort or in negligence cases? Let's say you are a juror. Here's someone who was shocked by intentional conduct of a defendant, and here's another plaintiff who is shocked by negligent conduct of the defendant. On which case do you think you will feel more sympathetic toward the plaintiff? The victim of intentional conduct or the victim of negligent conduct? Intentional conduct, right? So if you look at California cases cited by Illinois federal court, they are all intentional tort cases where jury as well as judges will feel a lot of sympathy for being wronged by intentional conduct of the defendant, right? So you'll see that when court changes from its precedent, from its previous precedent, usually it starts out with the easier cases. Okay, starts out with the easier cases that appeal to the ordinary sensibilities and sentiments. And we'll talk more about this because the very end of this semester we'll study constitutional law, and we'll do a quiz on a case that again changed the precedent. All right. Any question about the line of cases from Bosley, Eckenroth, and Niederman? You did all the reading in between, right? I'm depending on you to do the reading on yourself between cases. In class, I'm going through only cases with you, but all the reading in between, you should just do it yourself. And the exercise, you can do it yourself, and I told you there are answers in the backs, and you can grade yourself how well you are doing. Okay? All right, then let's look at other cases that I put online. Okay, let's start with the Kimberly versus Scott. Okay. Okay, what happened in this case?
Plaintiff was injured while crossing the street.
Okay. How old was plaintiff? Kimberly. Was she a child? Yes? Well, I'm not asking for the actual age, but okay. So Kimberly was a student at elementary school, and who is the defendant in this case? Farah. And who is Farah? Okay, and what did he do? What did he do wrong? Okay, what does it mean?
He didn't get out of the car, but was supposed to work doing and something.
Yeah, he was a crossing guard, and he was supposed to help the children cross the street safely to the school, but he was in the car, he didn't do anything. Why did he not do anything at that time?
Hours were from 7:30 and it was 7, and he thought no one would be calling. And was not responsible to work before them.
Okay. So if you look at, okay, it's hard to point you to the paragraphs. The third paragraph of the case, right in the middle. On the day of the accident, Farah was assigned to begin work at 7:30 a.m., which was his regular starting time in March 1980. He had no duties prior to that time and had no knowledge that children would be arriving earlier than usual. Okay. When did Kimberly arrive at the intersection? Like shortly after 7 a.m., right? So like 20 minutes earlier than his duty began. What happened in the lower court? Summary judgment in favor of who? Plaintiff or defendant? Defendant, right? Why do you think that? What's the law? Why was there a summary judgment granted, do you think?
A person who has not committed a crime is ordinarily not liable until the other forgery to take affirmative action.
Okay, so when you read case, you have to first decide what the issue is, and friendly judges just state the issue in the front of the case, but many judges don't do that. So usually the issue just you should be able to just extract it, right? So probably the case was decided on summary judgment because of this rule that you just read, that a person who has not created peril is ordinarily not liable in tort merely for failure to take affirmative action to assist or protect another, no matter how great the danger in which the other is placed, or how easily he could be rescued, unless there is some special relation between them which gives rise to a duty to act. So this is a typical case. So typical example will be, Olympic swimmer who doesn't rescue a drowning child in the swimming pool just because he had nothing to do with the child falling into the water, right? And you all learn in your Korean civil law cases that in that case, Olympic swimmer will not be legally responsible for the death of the child, right? And according to this rule, probably the case was decided in favor of defendant. But summary judgment I mean, it could have been decided on dismissal too, but probably the judge waited. The judge waited to see. So here is a dismissal. Here is a complaint, answer, and this is the opportunity for dismissal. After this, there is a discovery, right? And then here is a trial. Now, the case could be dismissed here, or the judge can wait to see whether there is any evidence, right? What evidence? Maybe evidence of some affirmative action. Maybe evidence of some act by Farrar in creating the danger, right? He waited and see, and nothing came, so summary judgment was granted, right? If you look at paragraph 4, not paragraph 4, 1, 2, 3, paragraph 5, the court said the only evidence introduced in opposition to the motion for summary judgment were excerpts from the deposition of Farrar. Those excerpts contained testimony of Farrar that he had been in his car for less than a couple of minutes when he first spotted Kimberly. Upon noticing Kimberly, he said, "My God, this hour in the morning." He thought it was a little unusual for her to be at the intersection that hour. He didn't get out of the car, blow his whistle, or do anything when he saw Kimberly. Instead, he remained in the car, hoping that Kimberly would cross the street safely. Kimberly appeared to be 9 or 10 years of age. Now, there, what does that evidence show? Shows that Farrar didn't do anything. And under the rule that if you don't create the danger, then you are not responsible for damages flowing from it, that is favorable evidence for the defendant, because defendant didn't do anything. Okay? Now, so what does the court say about motion for summary judgment? Does the appellate court affirm the summary judgment granted by the lower court, or reverse? Reverse or affirm the summary judgment? Okay, don't be confused. I'm asking you about the summary judgment part. Was it affirmed? Affirmed, right? So if you look at 1, 2, 3, 4, 5, 6, 7, 7th paragraph of the case, at the very end, the court says Farrar was, because the declaration of Farrar and Howerton established the lack of any duty to Kimberly, Farrar was entitled to summary judgment. Duty, I told you the 5 elements of negligence, the first one is duty, right? So the question you ask about duty is whether defendant did anything that makes him even accountable for what happened. I mean, not even legally responsible, but he has any reason to be careful toward the plaintiff. Right? Whether defendant did anything that gives him a duty to be concerned about the plaintiff's safety and welfare. if the defendant was like Olympic swimmer and had nothing to do with the child falling into the swimming pool, then legally that Olympic swimmer has no duty to be concerned about the child's welfare. Okay? So on that duty question, FARA was entitled to summary judgment. And then the court talks about the court's denial of plaintiff's motion for a new trial. Apparently, after trial, instead of asking for JNOV, the plaintiff asked for motion for new trial. 재심 신청한 거죠. 네. On what ground? Okay, on what ground? On what basis? Newly discovered evidence. What was the newly discovered evidence? Okay, you should speak louder.
Ms. McCready testified that in March 1980 he saw the crossing guard on the corner at 7 a.m.
Okay, most of the time. And she is, and Farah is what type of person? She's
Principal of the elementary school.
okay, but I'm asking. So she said what? She said what about Farah? What type of person Farah was?
Available type.
Available type. What does it mean? Available type. 그러니까 이제 이렇게 기꺼이 도와주기를 좋아하는 그런 사람이죠. So why does, and then the court affirms or reverses the trial court's denial of plaintiff's motion for new trial? Well, I'll give you the answer. The court reverses, okay, the court reverses the trial court's denial of plaintiff's motion for new trial. So the trial court thought that, that evidence should not be reason for a new trial, but the appellate court said, hey, that's a ground for a new trial. There should have been a new trial. Why though? How does this affect, how does the new evidence affect the legal standing of the defendant? Or the legal standing of plaintiff?
Because the new evidence can be given on assumption of duty for the defendant.
Yes, assumption of duty. I told you that there are like 4 different ways of proving duty, right? One is voluntary conduct, one is special relationship, right? Special relationship between, if the Olympic swimmer was a parent of the drowning child, then the Olympic swimmer will be legally responsible, right? And if the Olympic swimmer, like put oil on the swimming pool floor, that the child slipped on it and fell into the swimming pool, then the Olympic swimmer will be responsible. Okay? So that's the voluntary act. And one other situation is when, this is all in the PowerPoint, if you remember. If you're a doctor and your patient, okay, is about to commit a murder, right, then you are responsible for your patient's conduct because of the special relationship, because the special relationship in which the patient depends upon you. Okay? I told you about the case of Tatiana. And then there was one other theory by which duty can be proved. Do you remember what that was?
Applicable standard of conduct.
No, duty. Not breach of duty, but duty. There are factual situations. There are situations where defendant who didn't engage in any voluntary conduct creating danger will still be held responsible. So special relationships are one way. And do you remember undertaking where a person was trying to help the defendant? I mean, a defendant was trying to help the plaintiff, but put him in worse position than before? Do you remember the defendant who was trying to help a drunk person sleeping on the street and helped the drunkard up the staircase? But the drunkard fell, rolled down the staircase to his death. And the person trying to help the drunkard was held responsible for the death. Remember? Undertaking? Yes? No? Doesn't ring a bell? Well, anyway, assumption of duty. So duty can be assumed, right? So if you try to help somebody and make that person depend upon you, but put him in worse position than before, then that also gives rise to a duty. So here, the fact that Farah was there before 7:30, most of the times, that could be evidence that children depended on his presence, even before 7:30. Okay? And by not doing anything, Farah put the children in a worse position than he has not done anything, right? If in the past Farah started working only after 7:30 a.m., children would have been more careful in crossing the street. They would have trained themselves into being more careful because there is no crossing guard available. But because Farah continued to show the pattern of being available for the children in the past, okay, the children could have depended upon Farah's presence, which made them more vulnerable when Farah is not there. Okay? That's why this evidence could solve the question of duty, right? And it is the question of duty. It is because of the question of duty that the case got removed on summary judgment, right? And that problem would have been resolved could have been resolved on this evidence. That's why the court reversed. So now you can see how important legal decisions are made on appellate cases. I told you I'll end early today, and I will end early. I came in late. It's about an hour that we did, so let's just finish at this point. We'll read the rest of the cases. Read the rest of the cases in a similar a similar light. Think about what legal questions disposed of the lower courts. What rules, what laws affected the lower court's ruling, and what law the appellate court is applying in evaluating the lower court's decision. And the cases are all interconnected. You will read Winkleman, which is cited in Scott versus Farah. Okay. And then read the contract law PowerPoint. I'll give you a lecture on contract law. Okay. All right. Thank you, and I'll see you next week.
다음 퀴즈는 언제예요?
다음 퀴즈는 10월 13일이 중간고사죠.
네.
그러니까 10월
저 11일 날 그럼 수업이 있나요?
11일 날은 수업 있죠. 13일 날은 수업 없고 중간고사 안 본다 그랬으니까 13일 날 수업 없고 5일 뒤 18일 날 수업 없고 그 10월 20날 나 참 그렇구나. 화요일만 수업이지. 25일 날 퀴즈.
그날이 두 번째 퀴즈.
네, 두 번째 퀴즈. 컨트랙트. 자.